This is a talk that I've given a version of before, so hopefully it's not boring, but unfortunately, it's relatively popular as a subject because it really does touch on issues that hopefully will not, but likely will affect all of us. So these are my disclosures. There's none that are relevant for this presentation. So what we want to talk about first is what is malpractice? And there are these four elements, and this is something that I think is misunderstood. There's a professional duty owed to the patient. Of course, we all have that as physicians. And there was a breach of that duty, and that's really the key. It's not the third part, that there was an injury, and not the fourth part, that there were damages. It was the breach of the duty that we owe to the patient that makes it malpractice as opposed to a bad outcome. So what are the most common types that we see? Well, these are all fairly obvious: misdiagnosis, a delay in diagnosis, failure to treat something that should be treated, surgical malpractice, something that happens during the operation, birth injuries, and defective medical devices. So a little bit of context about malpractice. It's a subset of tort law. And the negligence is a conduct that falls short of some standard. And in tort law, generally this means a reasonable person. I'll come back to what that means in our context in a little bit. But this derives from common law, and this is under the authority of individual states. So this varies quite a lot between the states. So the process, this is initiated by filing a summons or something like that, and then the patient needs to prove these four elements, and they need to prove that this did fall below a standard of care that a reasonable, similar situated professional would have provided. Now, in general, the requirement is that each of the sides has an expert on their side to provide the context within a case, but that's not always true. There's this Latin term that essentially means that the case speaks for itself. For example, wrong site surgery or leaving in a foreign body. This does not necessarily require an expert. Then, of course, they want to determine that the breach did cause some sort of injury, and then potentially damages are awarded. Now, mainly these are monetary damages because of the loss of work or things like that, but occasionally there are punitive ones. I'll give an example here in a little bit. That's very uncommon in our field, but not unheard of. And some of these will go to trial, most do not. Now, trial is rare due to our system, the adversarial system, which is the one we're familiar with, where people are examined and cross-examined, as opposed to an inquisitor system where a judge or someone does all the questioning themselves. There's a process of discovery, which includes these documents, and then there's interrogation, then depositions eventually. And what is learned in this discovery process is what is used in the trials. There should be never a surprise in a trial, unlike what you see on TV. The burden, unlike a criminal case, is more likely than not. So this is not beyond a reasonable doubt, but rather more likely than not for these cases. Now, how do lawyers play into this? There's a lot to be criticized about our system of doing this, but generally on the plaintiff side, they work on contingency, and so they're interested in cases that they think they can win, and usually that will have very high value for them, monetary value, and won't take cases that maybe are good on their face but don't have those advantages for them, whereas the defense is typically appointed by the medical malpractice company. This is actually a huge portion of our medical outlay every year in the United States. Most of these cases do not go to trial, but nonetheless, they're a pain. So why do patients sue? I think that we all know this, unfortunately. It has very little to do with outcome and has a lot to do with how the patient perceives the treating physicians. So this was quite an old study a long time ago, but they looked at these depositions and read these depositions pretty thoroughly, almost 70 of them. And what came out of these? Well, most of the time, the patient just felt they had a very poor relationship with their provider. They felt deserted. They felt their views were under or devalued. They felt that the information was given poorly, and the physician didn't really understand where they were coming from. About half of them said that someone else suggested the malpractice, so I would keep that in mind when you're talking to your patients, especially when you're doing second and third opinions. You may want to stay out of that. And the post-outcome consultant, that person who was a second or third, was named in the majority of these cases, as they tend to name everyone. So are you likely to be involved in a suit? Well, sadly, the answer is yes. This is a survey done, about 20 years old, but this was done through the AUA. Not many people responded, as these surveys go, but of those who responded, most reported being named in a suit with a mean of over twice. So these are people being named multiple times. Now, were patients successful at trial? No. 4%. Either urologist was successful if something went to trial, but of course most didn't go to trial. They were dropped without any kind of financial settlement, or there was a pretrial settlement. Now, how do people respond to this? They respond in a way that's predictable and very sad. These are these people who are hopefully going about their business, trying to do a good job for patients. They may consider not taking on the difficult cases they took prior. They may limit the scope of their practice. They may even consider moving to a different state that feels more favorable to them, or leave practice altogether. This was just a map done, different study, and you can see there's a lot of heterogeneity in the United States in terms of how many cases were filed in this one. These were jury cases in this particular study. What kind of cases? They're all over the place. Unsurprisingly, oncology represents the majority. Failure to diagnose prostate cancer, that was the number one. And I'm not going to go through this whole list, but you can read here. So it's really a little bit of everything. So does anyone know what the largest medical malpractice award in the United States is? This is a nice piece of trivia. It's a urology case, and it was just from November, just last November, $412 million, most of which was punitive. And this was from a health clinic in New Mexico where the patient went in for fatigue and obesity, and they ended up getting Trimix and had penile fibrosis, $412 million. I'm sure this will be appealed. There's no new information on this online that I can find. But it is interesting that unfortunately we get this dubious distinction of our field being the recipients of the largest medical malpractice award ever in the United States. So what are some ramifications from the physician's point of view? Well, once it's served, people freak out, as they should. They're in shock, they're outraged, they're of course denial, they're anxious that this is happening to them, and then they talk to their lawyer, and maybe they feel reassured, and maybe they don't. And then there's long periods where not much is happening, and these are bad times because people stew in their own thoughts. They have lots of intrusive thoughts and rumination about this. Many of them will have symptoms of major depressive disorder from the situation, adjustment disorder, maybe even physical illness as a result. This unfortunately plays into our own personalities as physicians. We tend to be fairly self-critical. We have a big sense of our own responsibility toward patients, and this is really an affront to that. So we take this as a personal assault and a loss of our integrity, and maybe a failure within our field. So how do we respond to this? Well, like the AUA survey, we may get very defensive. We may start to practice medicine in a way that's not really in the best interest of the patient, but is defensive in the sense that we want to protect ourselves from future problems. Maybe we won't treat lawyers. Maybe we won't treat the relatives of lawyers, or patients who have mentioned that they're involved in litigation with someone else, or they've been involved in workman's comp or something like that. Maybe people won't treat them at all. What are some strategies for us as physicians? Well, social support is critical, but also the restoration of mastery, recognizing that you are good at what you do, that you feel like you have some control in a situation in which control has been removed from you, and hopefully change the meaning of this. These suits, unfortunately, are all about money and compensation. They're not about your competence realistically, and shouldn't be seen as a personal attack, although we all feel that that's the case when that happens to us. So switching gears a little bit, the question comes up: what is an expert and an expert witness? Well, this comes from this standard, the Daubert standard, which is really more related to more scientific inquiries rather than medical. But it is a standard in which ultimately a judge typically will have to decide whether the opinion of the expert is something that is acceptable within our relevant community. It is not the only standard. There's also the Frye standard. So, for example, in Utah, where I practice, they use the Frye standard, which is a very broad way of defining this. And in Wyoming, they use the Daubert standard. Experts are different than other witnesses. Witnesses have to have firsthand knowledge or observation of what happened, but experts don't. We can offer opinions, and not necessarily based on firsthand, but on abstractions. The testimony that experts give does need to be relevant and hopefully reliable to be accepted. What qualifies one? It's hard to know. Of course, they look at your education and then the practical experience, and hopefully the practical experience within the field in which you're testifying. But this is a little more vague than you'd think. The court generally decides this, and the trial judge, especially with Daubert, has a lot of latitude to decide whether an expert is indeed an expert and that their things should be admissible. So does this vary by state? I just picked some states that were all over the place. I'm in Utah, and the expert doesn't have to be in clinical practice and can talk about a different specialty. California, you don't have to be a medical professional at all. Alabama, much tighter. You have to be licensed to practice and within your field. In Arkansas, maybe the vaguest, you just have to know more of the subject than a person of ordinary knowledge. Whereas Delaware, probably the tightest, you have to really live in Delaware, take care of Delaware patients, get referred Delaware patients by Delaware physicians, et cetera, et cetera. So there is a lot of variation here. Now, this is something that we all should be familiar with, but I'm shocked at how few of us are. The AUA has an expert witness affirmation statement, and you should testify within your own field, unsurprising. You should distinguish between bad outcomes, which is not malpractice, and bad practice, and there's this concept of the standard. Should not work on contingency, meaning that you are an expert. You are not an advocate. You're not on anyone's side. And you, as a result, you should be willing to testify for plaintiff or defendant equally. Now, why does the AUA have this affirmation statement? Because we as physicians are generally loath to provide services for plaintiff. We want to be on physician's side. But unfortunately, that sets up a situation where, because you need an expert on each side, the plaintiff has to find some hired gun who's willing to say anything. And while we as physicians complain a lot about the burdensomeness of this system, we're still reluctant to be on the plaintiff's side. And so, if you pay your dues to the AUA, then you have accepted this, and this is sitting there when you pay your money every year. And if you are not willing to do this, if you pay your dues and you're on the expert witness registry and you do not want to take plaintiff cases potentially, then you can be referred to AUA ethics committee for that. That is an ethics violation. So should you do this? Well, it's maybe. It's very detail oriented. I think it's made me a much better communicator and documenter with my patients. And it's looking at medicine from a completely different angle. I mean, it is absolutely different than what we do day to day. I do feel like it contributes on whatever side I'm on, because unfortunately there are times when you feel the plaintiff has a good case. Why not do it? It's super tedious. It can be really time consuming, and it can be very stressful, especially if you go to deposition or a jury trial. They're there to make your life a little bit miserable to some degree. So how do the lawyers look at this? Well, the lawyers just want to know what you're going to say at trial and how you're going to say it. And so they try to make the atmosphere nice. They're friendly, or at least at first. And hopefully that will let you open up and maybe volunteer more information than you should. They want the whole story. They don't want surprises. They do want to lock you in, because what you say in the deposition is what you will say at trial. They do not want any wiggle room there, and there really shouldn't be anyway. So how do they evaluate you? They want to know, are you going to be good in front of a jury? Are you going to be credible? And do you hold up to cross-examination, or do you decompensate? They can ask difficult questions, hypothetical questions, all sorts of things. So what do they do when they're deposing you as an expert on either side? Well, they want to know where you're coming from. You know, where are you basing these judgments? They want to know how you handle cross-examination, and they can push you pretty hard to do that. They want to know what you read and what you looked at to prepare for this, because of course you're only responsible for the materials that you looked at. What do you look at when you have a question? What do you look at? Campbell's? Do you look at PubMed? And do you decide if someone else is a recognized expert, because then you're really relying on their opinion? They ask lots and lots of why questions. So some things that can be used against you, or will be used against you because they will, is they try to get you to blame someone, to blame a provider. They ask you multiple part questions that are hard to follow. They repeat the question over and over, hoping that maybe you don't answer the same way. Get you to agree to some premise that maybe you wouldn't agree to otherwise, or to make gross generalizations that they can apply to the specific case. They will ask you about textbooks or other definitive or standard texts so that they can lock you into those answers if you say yes. If you're in a deposition, be well prepared and be truthful. This is under oath. You don't want to have a perjury charge against you. You answer only the question you ask. Don't pontificate. Don't go off in a trial. Don't elaborate. A lot of us are teachers, but this is not the time to do any teaching. And don't let them fluster you. They'll impugn your character. They'll ask you if you're an idiot. An example I always use is one of my partners in Utah, who's an endourologist. They kept pushing him, and finally he just broke and said, but this person is clearly crazy. And they said, oh, I didn't see that you have a degree in psychiatry or and they really would not let this go. It drove him insane. But they did push him hard, and he gave in. Best not to be arrogant or hostile. The depositions are not conversations. They're questions, and you answer them, and you try to answer what you are asked. Tell the truth. Don't answer a question that you don't understand. Ask for clarification. Never guess, even if you have to get clarification many times. I don't know is a perfectly acceptable thing to say. You want to listen to the questions and only respond to the questions asked. A lot of us are bad listeners, especially if you have a multi-part question, and hopefully the other lawyer will object, but nonetheless, it's easy to get tripped up. Don't volunteer anything that wasn't asked. Don't editorialize, and really focus. Even if you need lots of breaks, that's okay. You want to avoid absolutes. You don't want to kind of get led into a question if it's misleading or if it's inappropriate. It's fine to take breaks. It's fine to kind of gather your thoughts. It's fine to take pauses and answer only what you know to be true without making guesses. You don't need to know the answer to every question. There's a tendency that we all have to kind of try to answer the question that we think is being asked because we know, but don't do that. Just answer what you're asked. This is just some examples of trials going poorly that have been published in various places. There was a nice little Medscape consolidation of these, but hopefully you can read this relatively small font. But the first one, the defendant surgeon was 4 hours late to his own trial. Showed up wearing some gold chains and a big diamond ring, and so the plaintiff was ordered over $1 million, and the defense attorney felt that it was because of their client and how they acted, their arrogance and the way they dressed. At Connecticut, it's very similar, dressed very fancy and very show-offy, and the jury foreman made comments to the defense afterwards. New Jersey, the defendant refused to sit where he was told to sit, kept talking extemporaneously and telling jurors his own version of things. That didn't go well. You want to be careful about talking about the case. There have been cases that have gone poorly because the person was discussing in the elevator, or speaking ill of the other side. You want to be careful about your social media, pictures that are available. You wouldn't want to show the picture that Dr. Kim showed of all the residents holding kidneys. That's probably not something you want to be discovered if one of those patients whose kidneys was removed had an issue. Don't want to be arrogant, don't want to be condescending, don't want to say honestly, because it all better be honest. That's all I have to say about that one. I'll try to end early. Thank you all very much for your attention.